My next case is Atlantic Union College versus the Assessors of Lancaster. The ATB had previously ruled for the appellant educational institution, Atlantic Union College, on their exemption claim under Clause 3rd. The appeals court reversed and remanded to the ATB for failure to, quote, state adequate reasons in support of its decision so as to permit meaningful review. The appeals court directed the ATB to explain whether it considered the 12 parcels at issue separately or instead reviewed the campus as a whole. Next. Now, there were a total of 30 parcels that constituted the entire campus. The ATB explained that the 12 subject parcels were variously used for educational purposes, notwithstanding the suspension of the taxpayer's Bachelor of Arts degree program in 2011. Certain other educational activities continued, including the Music and Performing Arts program, the Evangelism Training School, the Healthy Living Education, and the Teach Out program. In addition, the nursing students were allowed to live on campus as they completed their degree studies at Wachusett Community College. And the academic office continued its operations throughout the relevant time period. Next. The taxpayer continued to maintain the entire campus by paying for utilities, insurance, landscaping, security, and building repairs. The taxpayer never lost its charter, though it did temporarily lose accreditation for its degree granting programs. The taxpayer intended to resume degree granting programs and did so in August of 2015. When viewed as a whole, the subject parcels were occupied in furtherance of charitable educational purposes during the fiscal years at issue, 2014 through 2016. Next. The board approached the question of exemption of the subject parcels as an integrated whole. In a prior case involving Boston College, the ATB held that the scope of uses in support of charitable educational purposes for a college was wider than a case involving a single parcel. The ATB distinguished cases in which properties charitably owned were reviewed on an apportioned basis. And it was important that the taxpayer did not lease out any of the subject properties. Next. In treating the exemption question as involving the subject properties as a whole, the ATB concluded that they were occupied by a taxpayer in furtherance of the overall education mission. Even during the suspension of the Bachelor of Arts degree granting accreditation, the subject properties were used for interim purposes like passive recreation, overflow parking, and buffer space. The ATB stressed that the taxpayer was focused on regaining accreditation in the fiscal years at issue during the entire period it was suspended. And accordingly, the ATB reinstated its finding that Atlantic Union College is exempt from taxation under Clause 3rd of Chapter 59, Section 5.